each side will have 15 minutes. The appellant may reserve up to 5 minutes, and just let me know. And also, as you probably both know, we do record this, we videotape it for YouTube, so you need to stay behind the podium and not wander around the courtroom, and keep your voice up, as well as please do not use the names of any victims or any children involved in the case. Thank you.
Good morning, Your Honors. If I may begin. Your Honors, Jeremy Villette on behalf of Appellant Defendant Wayne Andrews. Your Honors, this is a case that highlights what happens when the racial concerns that have been permeating our justice system are allowed to bleed their way into a case. And this is not a case of overt prejudice. It is a case of what happens, though, when the rules are not actually adhered to.
Counsel, before you start even further or begin more, the 5 minutes, do you want that or not?
Oh, if I can just reserve 3.
3? Okay, thank you.
I apologize.
No, that's fine.
Your Honor, the central evidentiary issue in this case is a videotape that was played during trial that presumably showed the defendant with a pair of, who was African American, with a pair of white women in front of a bar in Highland Square. This is an incident that occurred, this interaction occurred before the interaction and incident that leads to us actually having the charges and being here today. Now,
same day, same general area.
Same, correct. It was about 2.5 hours before, if I remember correctly, Your Honor. Now, the thing is that we don't know who these white women are. We don't know what relationship, if any, that they have to Wayne Andrews. We don't know what was said in their interactions. We don't know anything exactly about what occurred. What we do know is that Detective Breeden, who did not speak to these 2 women, who did not attempt to find these 2 women, who did not attempt to speak to anybody in the bar about had they seen Wayne Andrews interacting with these women, was allowed to tell the jury that Wayne Andrews was accosting, and his description was basically trying to pull one of these women away, and her friend was trying to save her. That is essentially what his interpretation was, is that this black man was trying to take advantage and drag away a white woman, and her friend saved her. Why is that important? Because 2.5 hours later, a different video from the back of this area of bars, the alley in Highland Square behind the bars, shows the defendant and the alleged victim leaving a bar together. And the victim, a considerable time later, said that the defendant sexually assaulted her. And that, in fact, what happened was that he effectively took her away from the bar, took control of her and her car, and drove her away. That he basically drug her away and took advantage of her, consistent with what Detective Breeden was describing in this video. And we are in a situation where we have a justice system that, right or wrong, has a long history of an inherent prejudice under these circumstances.
Well, counsel, I think we can all agree if the justice system has a prejudicial impact on people of a different race, be it African American or what else, then it's wrong. So we don't have to talk about being right or wrong.
Well, and I don't mean it I don't mean it in that respect. What I do mean it, though, is when you allow a detective who has not spoken with the participants of this video to now give his interpretation of this video that is consistent with what, right or wrong, has been a long-standing prejudice, and we know can affect how a jury interprets evidence.
The jury did see the video.
The jury was allowed to see the video. The defense counsel, before trial, objected, argued vehemently against this video because of the racial overtones, because of the fact that there was no hint or cooperation of what Detective Reading was going to interpret it as.
And is there some, I believe I read in the briefs, the video of this man the man in the video is the same man that is being accused in this case.
According to Detective Reading.
The clothing was supposedly matched, though.
Yes, there were similarities,
Okay.
but as well, there was a mention of a watch, and there's similarities, there's differences. While the jury could say, yes, it's the same man, the reality of it is you still don't know anything about what the interaction actually was.
And the jury could have seen that on the video.
The jury could have seen that on the video, but, okay, so this is Wayne Andrews and an ex-girlfriend. Or this is Wayne Andrews and two friends, one of whom may be intoxicated, maybe not. Maybe they got into an argument. Maybe they're just having a conversation. Maybe they were talking about going to a different place and Wayne decided not to go. Or
Are you arguing that it was improper for the court to allow the video to be played, or it was improper to allow the detective to render an opinion of what it depicted?
under these circumstances, it's both. While the video could be relevant, while the video, presumably under the state's theory, could show motive or intent under 404B, that occurs only if Detective Reading is correct. There's nothing in the record that shows that he's correct. There's nothing in the record that shows that his opinion is more valuable than any other person. There's nothing to show him an expert on human behavior such that he could render an opinion or an interpretation about this video.
Well, that really sounds, in all honesty, more like a weight of the evidence type of thing.
Perhaps, but the reality of it is he, in a position of authority, was the only person allowed to interpret this video, was allowed to render his opinion about this video. He was the only person who got to get up there and say, this, and defense counsel had objected to it. The trial court had said, I'm going to let it in. He's going to be allowed to make his opinion. It was an improper opinion, and without any cooperation to show that it was in fact relevant or in fact did show motive or intent, it shouldn't have been presented in the first place.
I just want to stop you so I can clarify. Now, we'll obviously review the record thoroughly, but you're saying the defense counsel objected to the admission of the video.
Prior to trial, they had had arguments regarding this. The trial court had made it clear that it's going to be played, he's going to get to interpret it. So when it came time to actually do it, trial counsel at that point did not make a contemporaneous objection because he had already been shut down. And it was pretty clear. But it doesn't change the fact that the effect of this video is so grossly prejudicial, it's still plain error, even beyond that.
I'm just more curious about the detective's testimony, not so much the video objection. So you're saying that when the officer actually testified, defense counsel did not object?
Correct. He had already been put in a position, he was having to cross-examine the detective. But it doesn't change that it was still so grossly prejudicial, because there's substantial evidence in this case that did, and this also kind of hints towards the weight of the evidence argument, that didn't back the state's theory. While the victim blew a 285 and they said, look, she's intoxicated, this was 4 hours after her last drink. She told the police who arrested her for a DUI 4 hours later that she had been with friends. She made no mention of a sexual assault. Her actual concern was about her father-in-law, and from what he said, that was somebody she was pretty well scared of. The Wayne Andrews, the GPS records actually matched his description of where they went after they left the bar. This video colored everything, though, because once that video comes in, and once Detective Reading is able to interpret this way, well, this is just a black man who is trying to take advantage of a drunk white woman. And it was very clear from then on out that was, even when not explicitly said, that was still what was going on in this case. And it was the state's theory. Now, the one other thing I would like to point out regarding the sentences, the one point, and I know in the end it may not make a difference as to the actual term of the sentence, but it was plain error for the trial court to not merge the one abduction charge and the sexual battery charge. They were the same underlying facts. And as a matter of law, those two charges should have merged. Now, granted, the trial court did in fact make those sentences concurrent, so the end result might be the same, but as a matter of legality and a matter of as a matter of the justice system working properly, that is something that should be corrected, at the very least, even should Mr. Andrews' conviction stand in the end, he should at least have the knowledge that things were done properly, which is part of the point of an appeals process. But in closing, while there were other evidentiary issues, the key issue in this case is that video. That video colored everything about this case. You had a detective who lied to a defendant about when this incident occurred, so that when the defendant said, "Oh, I was not in Akron in mid-August," the detective said, "See, he told me he wasn't even in Akron." Come to find out, it was actually a month after that. So everything about this case gets colored by this video and gets colored by Detective Breeden's interpretation of this video, an unsupported interpretation of this video. Colors everything else about this case. And as a matter of plain error, and as a matter of the system working correctly, Mr. Andrews' conviction should be reversed, and this matter should be remanded to correct this error. Thank you.
Thank you.
Thank you, Your Honors. May it please the court, good morning. I'm Jacqueline Corrigan on behalf of the state of Ohio and the appellee, and urging you to affirm Mr. Andrews' conviction. The first thing I would like to say that it was absolutely unqualifiedly not the state's theory of this case, that this was about a black man preying on white women. And it's outrageous for counsel to even imply that. That was not the theory of the case. The state tried not to bring that in. We did not go there. This was not about, this had nothing to do with race, and in fact, the parties questioned the jurors during voir dire about their notions about race to make sure to inoculate them against such a proposition. Instead, what the video shows was that it was not about a black man going after white women. It was about a man who wanted to prey on drunk women. And any viewing, reasonable viewing, even by a layperson, of the videotape evidence in this case demonstrates that fact. As far as the detective's interpretation of the video, he was not doing anything more than any reasonable juror could have, and in fact did in this case. And I would remind the court that an evaluation of a person's intoxication is something that lay witnesses are permitted to opine on, because that's within the realm of experience of an everyday person, i.e. a juror. So when it comes to the detective's interpretation of the video, he was not doing anything more than any of those jurors could. And I would remind the court that yes, there was no objection raised to that detective's opinions when it was coming in testimony. And even though there was an objection to the video and opposition to the state's motion to use it, which we had done under Evidence Rule 404B, we made the written motion. There was objection to that at the time, but there was not any objection raised to the playing of the video during the trial. I would also remind the court that defense counsel used the video also. They used it to try to show that Mr. Andrews was not the person that the victim described in this case, because there was mention by her that she believed that the offender was wearing a watch. And defense counsel used the video to demonstrate that there was no wristwatch on Mr. Andrews at that time. And Judge Carr, getting to your question about...
Well, the defendant's use of the video is irrelevant if it was improperly admitted. Would you agree? I mean, that doesn't waive his argument that the court erred in allowing the video to be played.
No, but I would argue that it puts it into the realm of plain error for this court's review. Now, getting back to the actual law rather than assertions, the purpose of Evidence Rule 404B is that it is supposed to prevent evidence of character being used to show that somebody has a propensity to a particular character trait and that they were acting at the time in conformity with that character trait. The remedy for that, by the way, is not vacation of a conviction, but it is a new trial. And under Evidence Rule 404B, the evidence can be used for other purposes other than to show a person's propensity, such as motive, opportunity, intent, which is what the state used this for here, and which was clear from a viewing of the video, preparation, plan, knowledge, identity, absence of mistake, anything like that. It is not an exhaustive list. There is no requirement, by the way, that the other act's evidence has to come in through the testimony of a prior victim, as was propounded in the briefs. This court has to look at whether the evidence was relevant under Evidence Rule 401. In other words, did it have any tendency to prove any fact that's in consequence? This tended to show the method that this defendant used in making a beeline for a woman who was visibly intoxicated, trying to either separate her from her friends or making a beeline for a person who's already separated from her friends and directing her away for whatever his purposes were. So that demonstrated this defendant's motive, intent, and plan to target women who were intoxicated while they were separated from others, or to separate them, the intoxicated woman, from her friends. Then you have to look at the state's purpose in introducing this evidence. This was not for any propensity toward any character trait, and it certainly was not to try to paint Mr. Andrews as the stereotypical black predator. That was not it. The purpose here was to show that Mr. Andrews had the opportunity to use force on this victim, just as he attempted to do on another potential person. And our purpose was also to show his intent in approaching this victim from behind, and to show that he had a pattern, not of any kind of character trait, but he had a modus operandi of targeting intoxicated women. And then the third step of the analysis is there such a danger of unfair prejudice? Not prejudice, because all evidence is prejudicial, but unfair prejudice that substantially outweighs the evidence's probative value. And that test comes from Evidence Rule 403A. In this case, there was no danger that unfair prejudice would substantially outweigh the probative value of this evidence. Prejudice is only unfair when it invites the jurors, when the evidence invites the jurors to decide the case, not based on the facts in front of them, but on impermissible motives such as emotion. And again, in order to inoculate the jury against an improper basis for convicting Mr. Andrews, the jurors were asked in voir dire about their opinions about race.
In this case, did the court give a limiting instruction after the video was played?
Unfortunately, they were not. The state did request one, but the court did not give one. Even if this court, oh, Your Honor, I see a question.
Was there an explanation as to why they did not?
No, unfortunately there was not. It was simply, it was not It just was not given. But just to also add that even if there were error, the error is harmless because we have the victim's testimony corroborated by physical evidence that overwhelmingly led to the conviction in this case. And concerning the manifest weight of the evidence, I would remind Your Honors, this defendant's testimony did not line up with physical evidence until Detective Breeden informed him what the evidence either was or what the evidence could be. For instance, Detective Breeden mentioned that they might have swabbed the steering wheel of the victim's car. Until that point, Mr. Andrews denied that he had driven the car. After being told that it may have been swabbed for DNA, then he admitted, yes, he had driven the car. For instance, we have the video evidence that he was there at the bars in Highland Square that night. Until confronted with the information that video existed, and by the way, that's another reason why we used the video, was to show that his statements that he wasn't even there that night was false. Until he was confronted with that evidence, he did say that he wasn't even in Highland Square.
Well, the defendant says that he was told it was a different time period. Like earlier in August or early September as opposed to mid-September. When he answered that question, is he wrong with that? Or?
Well, there was a point when I believe, if I'm not mistaken, I believe he also said that he wasn't in Akron at all at one point. But also, he's confronted with the records from Uber. He says that those are mistaken. Everything else actually, I'm going to simplify this. Everything that we have that's physical evidence, the Uber records, the friends' accounts of where the defendant was, the witnesses' accounts of the victim's interactions with people at the bars that night, all line up with the victim's account, even though it was a fuzzy account because she was admittedly highly intoxicated that night. So it all lines up with her testimony rather than his. And the only reason why his starts to line up with some of the physical evidence is after he's told about what it was. And as far as the consecutive sentencing and the allied offenses, I would remind the court that the standard for both has to be plain error at this point because the defendant did not object to his sentence when it was imposed. He had argued that it shouldn't be, or that these offenses were allied. The court found otherwise, sentenced him accordingly, and the defendant did not object. And unless the court has other questions, unless the state says something else that she will probably regret, the state would thank the court and urge this court to affirm.
Thank you. You have 4 minutes and 8 seconds remaining.
Thank you, Your Honor. If I may, to return to the easier of the two central arguments, with the manifest weight, Your Honor, the state says that Mr. Andrews' presentation does not line up. As yourself, Judge Keolis, pointed out, the state says, well, he lied about being in Akron. Well, the defendant said, I was not in Akron, I was not in Highland Square, when Detective Breeden was telling him, well, this was in mid-August, early September. When Detective Breeden finally tells Wayne Andrews the date that this was supposed to occur, on that phone call, Wayne Andrews goes, let me check my phone. Oh yeah, I was in Akron. He starts describing the victim who he had interactions with. In his conversations with Detective Breeden, he describes their interactions. At one point, he describes how she used drugs in the car, drugs which showed up in a subsequent drug screen from the hospital, which she denied using. He described a knife that she had, that he says she brandished on him. Both of these occurred before Detective Breeden ever made mention that there was a knife. Detective Breeden never told him that she had come up positive for drugs. Wayne Andrews presented a consistent, he described where they drove. At trial, GPS records matched what he described their driving, matched the timing.
But there were other items that he denied, like the driving the car, for instance.
At one point, at one point he denied driving the car, but my interpretation was he was denied driving the car at a certain time, and it kind of changed along the way. Yeah, but I mean, you're also, even if you say, okay, he denied driving the car at one point, okay, he was probably drunk too, let's just be honest. But it doesn't change the fact that when it comes to a description of interactions, he consistently provided facts that showed truthfulness, as well as the fact that the victim who says that this occurred maybe within a half hour to hour at the most after they left, in terms of the sexual assault, tests a 285 4 hours later when she has said she was not drinking subsequent to leaving the bar. So for 4 hours she didn't drink, and yet she still registers a 285. To the deputies who arrest her for the DUI and test her, she says she's been with friends, she's given descriptions, she's having a freak out about her father-in-law. So I am not, and Wayne Andrews was not denying he was with her. But the reality of it is even on the manifest weight, there is a substantial amount of evidence that shows that she was not credible in this respect. Am I going to stand up here and say that she's just bald-faced lying? I don't know. She might have gotten to the point she's convinced that this is what happened. But the reality of it is that when you go down through all of the evidence, it shows that Wayne Andrews was far more correct than she was in terms of what the physical evidence backs up. And that leads to the question of, well, why would the jury so discredit this? Well, because apparently he's a predator. Now, as I stated at the very front end of this is not an issue of overt racism. But when you start interpreting this video with what it shows, experience shows the implications. Experience shows what's going to happen.
Did the state refer to the defendant as a predator?
I believe in closing arguments is when the word started getting used. Prior to that, it was not used. But once we got to the end, once he got to closing arguments, they were talking about him going after the women, and I mean, it started raising concerns. But at that point, at that point, the horse was not just out the barn; it was down the field.
And with that, you are out of time. Thank you. Thank you both for your arguments to the court today. As you know, we'll take the matter under advisement and issue a written opinion that will be sent to both sides, and we will also release online. So thank you so much.